Okay, so welcome to another edition of Just Talking with the Institute for Internet and the Just Society. My name is Petar Pesic, and together with my co-host, Ms. Nidhi Singh, we will be hosting this talk with Professor Thibault Schrepel. So just first to introduce ourselves, my name is Petar Pesic, as I said, and I'm an iGaming lawyer with the education from the University of Niš, Serbia, and the LLM finished at the University of Cambridge. I've been working as a consultant for the past 5 years in the area of competition law. Ms. Nidhi Singh is here to join us, and she's a practicing counsel before the Supreme Court of India and Deputy Director, Center for Computational Law and Policy, GLA University of India. She holds a master's degree in law and policy from Stanford, Oxford, Harvard, and King's College London. So it's a pleasure to see you all. Today we have a very specific, a very interesting topic, which is about the current shape of competition law and policy in the digital era. For this session, we shall explore the contours of computational law and computational antitrust, which is a niche, let's say, of Professor Thibault Schrepel. As such, computational antitrust is a specialized field of computational law that purports to improve antitrust analysis and procedures by assistance of legal informatics. The implementation of computational methods is essential to improve the overall functioning of antitrust agencies. This is particularly important in light of the recent cases against the big tech. So first of all, I will just shortly introduce Professor Schrepel, and then I will hand over to my colleague Nidhi, who will be conducting the first part of this talk. So Professor Thibault, Dr. Thibault Schrepel is an associate professor of law at the VU Amsterdam, or the Vrije University, I think it's pronounced, and a faculty affiliate at Stanford University's Codex Center, where he has created the Computational Antitrust project that brings over 55 antitrust agencies. He also holds research and teaching positions at the University Paris Panthéon-Sorbonne and Sciences Po Paris. He is a Harvard University's Berkman Klein Center alumni, a member of the French Superior Audiovisual Council Scientific Board, and an expert appointed to the World Economic Forum. In addition to this, he has written the world's most downloaded antitrust articles of 2018, 2019, and 2020. And last but not least, on a more personal note, he is passionate about 90s rock music, free jazz, Seinfeld, and B movies. So I do hope that I will be hosting you at the Nishville Jazz Festival in Serbia, one of the biggest in the world. That will be all for this short introduction. I will be handing over to my colleague Nidhi, who will conduct the first part about the computational antitrust. In the second part, I will be joining in and leading the talk on the future of competition law. And of course, at the end, we will have some short time for questions of the audience. So if you have any questions, please ask, and we will make sure to pick out a few of the interesting ones to add them to the professor. So please, Ms. Nidhi, have a go.
Yeah, thank you. Just wanted to check, am I audible? Yeah, thank you so much, Peter, and a very warm welcome to Professor Thibault, who agreed to give us the time. Without taking much time and much ado, I would like to put forth my first question to you, to Professor Thibault, and especially this question is all the more close because I, as part of a cohort of the JSM cohort at Stanford Law School, and where Professor Thibault has recently started a center on Codex. I started a work on computational antitrust at Stanford Law School. Makes it all the more intriguing to hear his thoughts on this. So my first question to you, Professor Thibault, is that could you, to begin with, could you explain us a little bit as to what are the technology foundations of computational antitrust? To begin the session so that it's also clear to the audiences who've joined us for the session.
Of course. Well, first of all, I'm delighted to be with you and to be able to have a dialogue and conversation on such an important topic from so many different perspectives and backgrounds. It's going to be great. So I'm grateful for that. To answer your question to the best I can, you could actually address the question in two different ways. You could say that, first of all, if you look at the definition of what is a computational tools, well, it's a computer-based problem-solving method. So everything that uses a computer is potentially, you could argue is about computation, and therefore, if you use computer to address legal issues, then you deal with computational law, which is a very broad definition. But then if you look at it from a more technical and expert angle, and you did mention and use the term legal informatics in the introduction, then what you are referring to is are some more specific tools. So of course, AI is at the very center of computational law or legal informatics. So here what we talk about, to be very specific, are several sub-technologies of AI, such as machine learning. So machine learning could be supervised, unsupervised, or deep learning, depending on whether you give the outputs to the machine or not, or just the inputs. And I'm sure we will be discussing that today. You could use agent-based modeling. Here, what you do is that you create a simulation. Of course, it's a computer-based simulation. And in that simulation, you may create as many agents as you want. And each of those agents will have agency. Therefore, the means to act as an independent agent and not according to a general pattern. So that also is central to computational antitrust. What you also talk about is legal text analytics, and most specifically, it could be natural language processing and natural language understanding. So here what you do, the very basic idea is that you provide lots of documents, hopefully at least millions of documents to the machine, and the computer will actually come up with some sort of analysis, depending on the order that you give and the instructions. So that's another one. Computational game theory is another one you may want to discuss, or network analysis. So here, that's something that we see outside the field of antitrust. What you do is that you take, let's say, all the decisions published by the European Court of Justice, you label the decision, so you say, well, this is a decision about IP, it relates to patents, this is the duration of the patent, etc., etc. And then you try to to create a way to visualize the data, and you put all that into a network to see if there are connections and patterns that emerges from all that. So that's the one side. Another side that we forget sometimes is the one of blockchain, which is also a computational technology, because I do believe that it might be central to not only companies wanting to infringe antitrust, but also to competition agencies willing to improve their processes. But again, we'll be discussing that today. You did mention the Computational Antitrust Project, which indeed is now ongoing within the Codex Center at Stanford University. There are lots of agencies, 55 agencies, part of it. And I've written a paper at the start of a project, which is only 15 pages long, trying to explain this is what computational antitrust is, so which is, the merger between computational law and antitrust. And this is what is possible to achieve, but those are also the limits that we will be discussing. So I hope I answer your question. It's a bit broad, but very exciting nonetheless.
Yeah, thank you so much, Professor Thibault. I think, I had an opportunity to read that paper just before the session on the 15 pages paper that you mentioned on computational antitrust. And it is from there, after reading that paper, that's where I get my next question from, where we want to understand as to how, though you broadly mentioned that in that paper, but we would like to know from you as to how does computational antitrust apply to anti-competitive practices, merger control, and to the to the overall monitoring of competition policies across jurisdictions. So it will be helpful to know your perspective on this and its application in competition law. Yeah.
Of course. So you do have several issues here. When it comes to anti-competitive practices, you do have two main issues. The first is to detect those practices, we have some empirical work, although a bit outdated, but coming from the US and Europe. Unfortunately, I'm not aware of such work for India or Latin America, but this would be very convenient and useful to have. But that work shows that we detect almost, let's say, between 10 and 20% of infringements to antitrust or competition law, which is not too good, to say the least, because it means that if you infringe antitrust, in 90% of the time, you will be fine. And so therefore, the ability to detect more practices is very important for agencies. And this is where computational tools could help. If I may just give you two examples, one could think about designing an API that would send some data from the companies automatically to the agencies. This could be a way to detect. There are lots of work coming out, for instance, of the MIT, trying to show that there are patterns that you could use to detect practices out there on the market. Another way of doing it is natural language processing that I already discussed. I mean, we know that companies have to publish lots of information, especially if they reach a certain size. They do have to send financial information to some agencies, data protection information to others. And it seems that combining this publicly available information and using natural language processing to analyze it could be also a way to detect more practices. So that's the detection part. But we also have another one, which is the analysis part. And hopefully we are going in a direction where we could improve our analysis. What we do today, but that's something we will discuss, is that our analysis is very much static. And I'm not blaming it on anyone, because if you talk about being more dynamic and try to understand what's happening on the market, we don't have the proper tools to do that. So as an agency, you need to, use the tools that you can rely upon. And for now, they are mostly static. And computational tools could help in the matter, using machine learning, for instance. That's one of the paper that we published within the project. You could actually try to train a machine learning based on past case law, something that we know all antitrust agencies have, and try to detect new patterns. And there are things that you see that emerges from those analyses which are invisible to the human eye. So that's for anti-competitive practices. For merger control, the issues are a bit different, because most likely you don't have a detection problem. There are some companies merging without notifying agencies. It's called a gun jumping, but it's quite rare. But another issue that you have is that you have lots of data, and you have the time constraint, which you don't have when it comes to anti-competitive practices. So if you only have 90 days to come up with a decision, then you must be able to analyze millions, if not billions, of data entries in just 3 months. And that's a challenge. And that's where also some tools are already being used by agencies. And it seems that we could use more of those to try to predict what will come in a bit of a more specific way, because that's also something which is specific to merger control. You try to see what is going to be the state of competition after the merger or without the merger, which is predictive by nature. And that's quite the opposite when it comes to anti-competitive practices, because what you do, at least in theory, is that you look at the past and try to understand the effect that the practice had on consumers. And so again, it is that agent-based modeling could help. And the idea that we need to rely on the average consumer probably needs to go away. That's something that I always do, very first class of computational law with all of my students. I talk about market definition and the average consumer, and I take the example of a coffee. And I say to my Dutch students, how long are you willing to walk to get to buy a good coffee? They would say 5 to 10 minutes. And then I ask my Italian students, how long are you willing to walk? And they would say, well, half an hour, or if not 2 hours, because coffee is very important. This idea of average consumer doesn't really work. That's the best that we had, but it seems that now we can improve a bit. And to finally answer the multi-jurisdictional part of your question, some of the work that we published I find to be very interesting, because what they try to do is to train a machine learning system using, just talking about the US, the DOJ antitrust division case law and the FTC case law. But the case law was too different for the algorithm to come up with something which was consistent enough for them to be able to use it. And so it goes without saying that should you try to train a machine learning using, let's say, US and Europe case law, the machine learning won't function because the case law is too different. So it might be that because we need to use those tools and to train machine learning, we will see more convergence about the substance of antitrust, which is, a bit reverse, but it might work this way. And if so, this will be a great news for everyone.
Yeah, thank you so much. I think that was quite a detailed answer that you gave, breaking it as to its application to anti-competitive practices, merger control. That brings me to my next question, Professor. We would like to know from you as to, is there any relationship between computable contracts and computational antitrust? And if there any relationship exists, could you elaborate on this and let us know about the kind of relationship that exists between these two objects of computational antitrust and computable contracts?
Sure. So, I mean, is there any relationship? Yes, could be, not necessarily. What we know is that some infringements to antitrust are contract-based. So, for instance, you have implemented a rebate scheme, and it might be anti-competitive because it's not only based on the quantity, but there are some qualitative criteria. So here you do have a contract. And so in a sense, you could argue that should you come up with a computable contract, so a contract that will be automatically drafted or executed using computational tools, you could try to come up with some compliance by design sort of solutions. And so, for instance, you could say, well, I want to impose that every company is implementing a rebate scheme has to come up with this sort of computable contracts and use this sort of templates. Although I see the dangers of doing that as well, which is that you have the regulators trying to tell companies how to conduct business. So there's probably a middle ground here to be found. But we could come up with some solution, and I'm sure we will in the future. I have written a report on smart contracts for the European Commission, and I addressed this question of templates, whether we should use templates, what's happening, is it the role of regulator to try to come up with some good computable contracts for companies to use and all the limits of that. So the report will be published in just a month. So if you are interested in those issues, please keep an eye on it. But most of the time, if you infringe antitrust, there is no contract. I mean, if you create a cartel, you may draft a contract, often, on a napkin, because you create cartels in restaurants. Apparently, that's something that companies do. But this contract is not enforceable. Of course, it's impossible for you to go before a court of justice and say, please enforce my cartel, my illegal cartel, because the other colluder now tries to leave the cartel. And if you talk about abuses of dominance, sometimes you do have contract, but most of the time you don't. Talking about self-preferencing, something which is quite trendy. What's happening here is that you have a company owning a platform or aggregator and trying to use that to promote new products and services. So you have no contract. The company is not drafting a contract with itself. And so here, the link between computational antitrust and computational contracts is not exactly clear. So potentially the two should be combined. I'm not aware of any study trying to see how computable contract could be used in the field of computational antitrust, but I'm sure we will have a few in the future because again, this is the direction that we are taking no matter what. And it's very important to be aware of all the limits in the field. I don't want to give the impression that I'm just an evangelist. I have no stock option and I'm involved from an academic perspective, but there are limits and it's very important that we discuss that, which we will do in just a few minutes.
Thank you so much, Professor. With this, I would like to move our discussion more towards the big tech side and its interaction with the competition law. And the next question that we would like to know your thoughts on is that, provided there are so many myths and issues surrounding the tech tycoons today and its relationship with law enforcement agencies, most particularly the competition agencies, do you believe that there will be any long-lasting effects in competition policy as a consequence of this seasons of numerous investigation and lawsuits against the big tech as we see in Europe, US, and for that matter, even in India? And a follow-up question to this, which I could combine with this part itself, is that, do you think that the competition authorities as such are sufficiently equipped to keep up with the speed of digitization? Would love to know your thoughts on this, Professor.
Sure. So, I mean, I'm of the opinion that competition law is already being transformed. So it's not even a matter for the future. If you look at the DMA, the Digital Markets Act in Europe, for instance, of course, it's just a draft, so it might change, but it looks like it will be voted and implemented in just a few months. This is competition law, despite I'm aware that in page 8 of the DMA, the European Commission does say that it's not competition law, this is a complement, this is something totally different. But if you look at the practices prohibited in the DMA, Article 5 prohibits self-preferencing, which is exactly the Google cases, prohibit the use of personal data from one product to improve another product, which is the Facebook case before the Bundeskartellamt, the German competition agency, and the list goes on and on and on. So the DMA is about competition law. It is sure a complement because it means that agency will be able to use competition law the natural way or this more regulatory way. But this already is a transformation of competition law. Same is happening in the US, the exact same. With some of the acts upon Congress right now, some are going a bit further than the DMA is where the DMA is going. Some are trying to backtrack a bit, but that's the very same logic. As for the enforcement of competition law, for me, what a crucial moment will be mid-October when the General Court will publish the Google shopping decision. And depending on whether they approve the decision of the European Commission or whether they actually give some more room to Google, then it will, I guess, the face of enforcement will change dramatically in the years to come. So hard to answer the question as we speak, but in about 2 months, I guess we'll have more clues as to whether enforcement will be changed. But still, there are some issues. I'm sometimes a bit skeptical that all antitrust cases against digital products and services are really the best way to improve consumer welfare. I can see how they improve consumer welfare when it impacts the entire ecosystem and lots of startups and small companies. However, when it's about improving the welfare of certain users using just one app, I'm not too sure this is the best way to spend resources. But nonetheless, I think it will continue, and rightly so, because some cases are very important. So regardless of the General Court decision, we will see more cases in the years to come. But still, the burden of proof, the way to address consumer welfare, all that will be, at least for the European parts, determined by this decision. So we'll see how it goes. And to the second part of your question, are competition agencies equipped to keep up with the speed of the big tech companies? They are also getting equipped. So it's happening as we speak. As I mentioned, we do have 55 competition agencies, which are part of the Computational Antitrust project. I've seen lots of enthusiasm in the space when getting in touch with them, from big agencies to very, very small agencies with just a few employees. Some of them have published press releases to make it known that they were engaged in trying to modernize and to use computational tools. So we are going in the right direction. Several agencies are hiring computer scientists. The UK, the CMA has, last time I talked with them, over 60 computer scientists working for them. The DOJ sent all of the employees to the MIT to learn about AI and blockchain from a technical perspective. The European Commission has the DG Digit. I could, same for the Dutch and the Italian, I could, mention lots of agencies. So are there sufficiently equipped as we speak? Maybe not all of them, but should we have the same conversation in 2 years, I think the state of what's happening will be much different. So again, quite positive about where we are going in this space.
Thank you so much, Professor. Would like to move to my next question, which is on cartels. And we would like you to throw some light on the cartels being formed in more analog sectors, that have started to use advantages of digitization. So you could say, for example, cartelists colluding in private chats these days, trying to make it even, which makes it even harder for the competition authorities or the apex competition authorities across jurisdiction to detect those cartels. So would like to hear your thoughts on this, Professor.
Sure. I mean, the example that you gave is very, very interesting, and it relates somehow to the issues we have with blockchain, which is that indeed, if you use, I mean, I'm not going to give name, but some zero proof knowledge or fully encrypted private chat to collude, then it means that an agency cannot actually detect the cartel this way, which is to just, try to spy on those softwares and apps and try to see what's the conversation. However, at the end of the day, if you do collude and use whatever tools that you want in a way that is effective, it means that, let's say, prices will go up, or you will be able to detect some patterns out there on the market. And that is always visible. And that's where competition agencies could start investigations and then try to do a down rate and try to take the cell phone, whatever they want to do, and go back this way and try to understand the practice. Of course, it raises lots of procedural questions and questions of human rights and also the rights of defense, et cetera, but that's always a possibility. But now the question is, do we really have lots of those really complex cartels? The one that you mentioned, I would say, is scenario number one, which is just companies colluding and using computers or apps or whatever they want to collude in a way which is a bit better. We probably have a lot of that. I mean, I'm not too sure why, if you want to collude, you should use a piece of paper if you can indeed use those softwares and apps. So potentially, yes, the face of collusion is already changed because of those technology, but that's only scenario number one. Another one, which is a bit more complex and advanced, will be ordering computers to collude. So you will meet in a coffee with your competitor, and you would say, well, let's agree to have the same prices, but to be able to determine the best price, then we will ask computers and algorithms to come up with the best price. And of course, we join our computer so that the price is equal for all competitors on the market. We have a few cases. I can give you some references. Eturas is one. That's the case 74/14 before the Court of Justice. Another one is VM Remonts. That's the case 442/14. So we have a few of those. What happens most of the time is that you have companies using a common software or the company using a software to try to come up with the best prices for traveling, tickets, et cetera, and they are aware that their competitors are using the same software, and that's a way for them to collude. Just a few cases. Scenario number three, which is something that we as the academic community love to talk about, is computers colluding by themselves, which is that you have no human being behind telling the computer what to do, but it might be indeed that algorithms by themselves, whatever it means, will decide on colluding. I'm not aware of any case law all over the world discussing this type of practice. We have some empirical work showing that in a lab, it is possible for such algorithms to collude. But again, in real life, no such cases. It could mean that it's too complex for agencies to detect, or it could mean that it's not a practice that is being implemented as we speak. Really hard to know. But in the absence of proof, I'm of the opinion that we should probably focus on what you mentioned, which is scenario number one, which is using some more advanced softwares and tools to collude the old-fashioned way. And this is probably where most of the case law is lying.
Thank you so much, Professor. In fact, because this entire conversation has been about computational antitrust, and I do appreciate the fact that this is relatively a very new domain of competition law. But it would be interesting, even though it might be naive to ask, but it would be interesting to know what would be the general and specific challenges when it comes to computational antitrust. And if there are certain challenges, what would be the way forward to deal with those challenges? So would like to hear your perspective on this, Professor.
Sure. So there are many challenges, but I would probably try to summarize them all in 4 categories. The first relates to the field of antitrust that we can compute or not. When it comes to prices, then that is something which is hard enough for a computer to understand and to be able to calculate, which is to compute and to come up with a solution with. However, certain practices in the field of antitrust, as we all know, are non-price related. It relates to the quality of a product or the speed of innovation, et cetera, et cetera. And that is way harder for a computer to compute. So there are certain fields that we can already compute. If I talk about rebates, that's something that a computer could probably do, which is the entire, first of all, the ability to detect using web scraping tools and then do the entire analysis and calculate whether the rebate is pro or anti-competitive. When it comes to the quality of a product, it's much harder as we speak. I think it will get better, but this is not something for 2021. So the field is number one issue or challenge. The second one relates to the tools that we use, and most specifically, who should be in charge of developing those tools. If it's a private company, what's the type of contract that we have with an agency? If it's an agency, should the agency share the tool with other agencies? If so, how to do that? And once you have created the tools, you need the data to feed the tool. And so the question of how to create data feeds is central, because otherwise you may have the most wonderful software in the history of humankind, but if you have no data, then the software won't do anything for you. So those are the questions that we need to ask. And here it raises questions of procedural fairness and the right of defense, et cetera, et cetera. So that's number 2. Number 3, the role of computational antitrust should be discussed. Some things are hard to approach the hard way. And here I'm quoting George Akerlof, a Nobel Prize in economics, who last year published a paper saying that in the field of economic theory, some scholars went too far into the mathematical formula and trying to modelize everything, when in fact not everything can be computed or put into a formula. And the same is true for computational law. So for the fields or the practices that you cannot compute or the elements that you cannot compute, what should you do with that? And I'm a bit afraid that it might be easy for an agency or a company to say, well, there is part of this practice that we can compute, and there is another part that we cannot, and therefore let's forget about what is non-computable. I think this will be a mistake. And so the question has to, what to do when you have computable versus non-computable elements is central and something we need to address in the coming weeks or month before it's too late. And the fourth and final one relates to the limits of computational antitrust. Prediction is hard, especially when it's about the future. And so since we have no theory of everything, the question is, what's the limit that you give, and how do you take into account what some have been calling the black swan, which is the event which is impossible to foresee. I mean, COVID is a good example. If you wanted to compute the state of a market 3 years ago, your potentially computation would have been wrong because it was really hard to foresee COVID-19. So those are the limits. Despite the limits, something I would like to mention, however, is that you do have kind of the same limits in a sense for weather forecast. It's not perfect. It's just a prediction, but as we know, it's often wrong. It doesn't work very well. Sometimes it's much better to look at the color of the sky to try to see if it's going to be windy tomorrow than just have a look at the iPhone. But still, weather forecast is also very convenient. It saved lots of human lives by being able to predict when there is something huge coming up, such as a storm or anything else. And so we may want to use weather forecast. It is also improving. If you look at empirical data, the weather forecast is much better today than it was 40 years ago because of AI, because we are able to compute more elements. So despite the limits, this is not, at least for me, a break on research when it comes to computational antitrust, but quite the opposite. It should be something that should trigger the need and the desire to research those questions and try to advance the field, keeping in mind that there are limits that we need to address.
Thank you so much, Professor. That was a very good conceptual, good overview of the computational antitrust, which was the first part of our conversation for today. I would now request Peter to take us through the contours of the future of competition law and hear Professor's perspective on that. Please, Peter, to you now.
Thank you, Nidhi. Thank you. I hope you all enjoyed this fascinating first part of the conversation. Of course, I will just again remind you that you can ask questions to Professor Schrepel in the chat or Q&A session, or comments wherever you are watching this this session from. So, Professor, you touched upon the new legislation introduced or about to be introduced in the EU or the US. But speaking of the current legislation framework, what would you say would be, let's say, 2 or 3 of the biggest deficiencies that we have in the current framework of competition or antitrust law legislation?
So, I mean, for me, the biggest one, without any doubt, is the fact that we relate on neoclassical economic theory, and I'm about to explain what this is, and I understand why. So I don't want to give the impression that, you know, it was all wrong and it was a bad idea from the very beginning, because indeed I understand why. In the 50s and the 60s with the Chicago scholars, we at some point thought that potentially it would be possible that market will reach equilibrium, which is a state in which, you know, after competition has played out, no companies is gaining much market shares and everything is staying pretty much the same. And why it would have been possible also, and that's more the European side, to rely on what we called ordoliberalism, or the German school of economics theory, which is that the state and the structure of the market is what matters the most. As it appears that this is not the case. Some economists in the US have used a formula that I like very much. If it's in equilibrium, it must be dead. And indeed, I very much believe that if we talk about, you know, dynamic market and recent and new markets that consumers cares about, then most likely, or almost always, it's not in a static way, and you see lots of dynamism and competition playing out in a very Schumpeterian way. And so that idea that you are able to just take a picture of the market and act upon that picture and face the same picture for years while the investigation is going on, I think has to go away. And we luckily have the tools now, and also the substantial backgrounds to address that. Not that we have the perfect tools and the perfect way of doing it, but I think we can go in this direction. So to be very specific, I think complexity theory is something that we may want to investigate a little bit more than what we've been doing so far in the field of antitrust. What complexity theory is that you try to study and to predict how systems respond to the context they create. So it means that you have lots of agents in the market, those agents interact, these interactions will change the behaviors of those agents, and those behaviors will eventually change the entire environment, which is something that you see if you look at biology. You see species and varieties of those species. Competitions plays out, and then eventually you have some dominant species, and they will use the land in a certain way. You will change the environment. Those changing will end up changing the species, et cetera, et cetera. And so it seems that if indeed we want to address, which I think is excellent, by the way, the network of digital platforms and aggregators, and try to see and understand that there are different layers, and that owning the first layer might be crucial to competition, complexity theory is a good way and a good entry door. So that's something that I see as being as missing. And to be very specific, the idea that we are almost never discussing what David Tees called dynamic capability, which is the capability of a firm to evolve in the future. Same for technology. You see that certain technologies have a potential for evolution, which is much higher than other technologies. I think has to go away. It's very important that we address the technology being concerned by market practices, which means also to take into account the time factor, to try to understand a bit the movement of what's happening on the market, et cetera, et cetera. So this, in my opinion, is the number one thing that we need to address. To some degree, I'm not convinced that the DMA, for instance, is addressing all that. What it seems that the DMA is doing is that it takes a picture of what's happening on the market. Let me just give you one very specific example. The DMA gives a definition of what is a gatekeeper. And in the definition, you have several criteria, including the number of users, the turnover, and whether the gatekeeper is running a core platform service. But none of those are taking into account the time dimension. They do say that it should be over the last 3 years, but the idea that you may grow the user database or that you may see a decline in the user database is not encapsulated into the DMA. Well, it seems to me that it could be, and actually should be, because if you are TikTok and you double the amount of users every year, it means that potentially something is happening and advertisers may want to advertise on this platform instead of using a platform which is declining. I won't give name, but we all know platforms which were very popular 5 years ago and are not as we speak. So this idea of time and movement should be encapsulated. Not that we know exactly how to conduct and reform the entirety of competition law according to those principles, but we can start here and there because we know how to do it already.
Thank you, Professor. I think it also translates to one of my next questions that I want to ask you. So, because competition law has to be basically applied in the variety of industries and the basically whole economy, can competition law ever be really free of ambiguity in general, or do we have to leave it, sort of a more general approach so that judges and practitioners can actually apply it for a specific industry that we are concerning about in a particular case?
I mean, there are, and here I'm leaving the field of competition law and the legal field, but if you look at neurosciences, what you see is that when we speak, and I forgot the exact number, I think it's 94% of the time we get the exact message that was supposed to come our way, but which also means that 6% of the time, which is quite high, so it's 6 or 5%, I'm not exactly sure, but let's say 6% of the time, you don't actually get the message as it was intended. So, which means that, of course, if you use language, the idea of being free from of ambiguity has to go away because it seems to be nearly impossible. However, if we talk about using computer programming languages, there are, I mean, if you know how to code a little bit, you know that there are different ways to express the same function and to make a software work. But still, there are less ambiguity in this regard. And so it relates to, it comes to the question, can we compute the entirety of competition law? As we speak, I think it's far from being possible, but can we get there? Some people would say no. I'm of the opinion that yes, it is possible, at least in theory. I'm not sure if practically we will reach that point. But the disclosure that I should make here is that I do believe that we could compute the entire world. Should it be possible to scan every human brain and to scan the entire environment of the entire planet, we could actually know that in 2 hours, I'm going to feel the need to leave my apartment and to go to buy coffee. And that person will also do the same. And so you could predict an event happening out there. But again, as you see, this is far from being possible as we speak. Maybe with the aim of quantum computing, we could reach that and in a sense, get rid of ambiguity. But this means that there is potentially everything is predetermined and that we have no free agency. So I'm going to leave those questions up for philosophers. But yes, possible, potentially in 500 years or 5,000 years. But as we speak, it is not. So what do you do? If you are a regulator, a policymaker, well, potentially you try your best to come up with some sort of legal certainty indeed. And one way of doing that is actually to develop tools and computational methods potentially in a way that would work with companies instead of working against those companies all the time. So I will be very interested to see competition agencies coming up with a software. And I know that some of them do have the software already that says, well, please enter the characteristic of your practice, and you will get to not a perfect solution of whether the practice is for sure anti or pro-competitive, but you will get a good sense of whether it might be or not. And competition agencies could eventually provide such tools to companies, which will imply, which will increase compliance, et cetera, et cetera. So again, whether or not we can, eliminate any ambiguity is a matter for philosophers, but we can potentially eliminate way more than we do as we speak using computational tools. So let's try and see at least if it is possible.
Thank you, Professor. And I think you also have been very heavily involved in transforming the education of competition law in general, and how we are training the new generation of the competition practitioners. So maybe you can give us a sense of what it is that the new generation of competition law practitioners should be focused on in order to be successful in working for either regulators or for private practice.
Well, I mean, this would be by far the most personal answer, I suppose. But in my view, if you do not understand the technology, then you are going to become a dinosaur, and that's not what you want. So I'm not arguing that as a competition lawyer, you should be able to code Google from scratch. This is not your work. However, if you do not understand the basic of coding, or at least computational thinking, you will be lost. So something I can disclose, for instance, to be very specific, from the reports that I mentioned for the European Commission, I studied the functioning of smart contract and the functioning of blockchain. And what you see is that a smart contract is actually being triggered not by the users, but by the nodes. And so this is something which is very technical, at least in nature. But the legal implication of that might be that every smart contract as we speak is international in nature. And so it means that the Rome Treaty applies to every smart contract. And eventually that's the way by which you assign legislation to a smart contract. So should you have no technical understanding of a smart contract, then you can't actually reach this type of legal conclusion. So that's why I've listed actually on Le Concurrentialiste, I've made a list of open access resources that everyone can use, and I've tried pretty much all of them, and some of them are advanced, but some of them are very easy to use to try to learn what is computational thinking, how a computer function, what is an internet protocol, how to code something very basic to create a small video game. So that's something that I'm trying to do with my students indeed. Something that I enjoy, by the way. I'm aware that legal students will always say at first, well, I didn't come to law school to learn about how to code or to study mathematical formula, but there are ways that could be actually really fun. So that's the number one thing that I will, I mean, that's at least what I try to do with my students. And the more it goes, the more it's going to be necessary to understand the technology. We'll see how far it goes. There are some things which are very curious as we speak in the field of competition law. When it comes to merger control, you do have to understand the technology a little bit to try to define the market and see if there are some sort of efficiencies. When it comes to certain abuses of dominance, the technology matters very much, but some other times it does not. So the Intel case is a good example of that. The Intel case is a case about rebates, but at no point in the decision is the Court of Justice saying that the technology being concerned by the rebates mattered very much. So potentially that's also room, there is also room for improvement in the field. But generally speaking, trying to understand what's the technology, how it functions is key. I've written a short paper, only 3 pages, on the subject of platforms and aggregators, trying to explain that Google.com, Facebook.com, Amazon.com are not platforms, because what they do is that they combine existing information and serve the information to you the right way, hopefully. And if not, then it might be anti-competitive, which is way different from platform, which is a structure that anyone can use to build something on top of it. And so in the sense, you could argue that an operating system is a platform. And so again, this is not super advanced when it comes to technological skill, but should you have no technical understanding, then you cannot get to those distinctions, whether this one is a good one or not. But I think this is the future. So probably something for everyone.
Thank you, and of course you can visit the professor's blog. We have posted the website in our chat, so hopefully you can take use of the resources that Professor mentioned. So, Professor, we already earlier touched upon the consumer welfare as a sort of a higher goal of the competition law. So, how do you see the future of competition law enforcement with respect to protecting the larger consumer welfare? When it comes to the disadvantages that are caused by the manipulation of algorithmic pricing by the so-called platform markets?
I would say, first of all, wait for evidence, or should you work for an agency, try to gather more evidence. And for that, the CMA, again, is showing the way, using computational tools to try to gather more evidence and address what's the harm done to consumers. That's something which, in my view, but again, very personal opinion, is missing from some of the Google cases before the European Commission, where I think it's hard to argue that all practices at stake were pro-competitive, but if you cannot prove harm to consumer, then you do have an issue here, because what do you do for the right of defense, et cetera, et cetera. So evidence is central. I'm not convinced that the way we are taking right now to say that, well, the burden should be on the company and same for mergers is the right way. I'm not too sure that this will sustain analysis by the European Court of Human Rights, for instance, but we'll see about that. But that's number one. Number two, use computational antitrust. It is coming. We've discussed how competition agencies could use computational antitrust, but companies can also use computational antitrust to try to address whether their practices are compliant or not. And consumers could also use computational tools to improve, the way they behave on the market and the type of companies and product that they use and buy and consume. So that's something that, by the way, we already see when it comes to price comparison services. Hopefully, the service, the algorithm is not tired when it's 2 a.m., when you might be. It has no feeling toward one company or another. So those tools can help if, of course, they are fair and non-biased. Three, I would say that potentially something which is creating a more pressing issue is the one of blockchain, especially in the field of antitrust. Why is that? Because first of all, blockchain is decentralized, meaning that there is no single player running a public permissionless blockchain, which means that in turn, if there is an infringement to antitrust, there is no single person to who you can go to and say, please stop the practice and implement this type of remedy. So there is real barriers to enforcement. There are workarounds, but we need to discuss those. And potentially you may see the risk, and we have a few cases already out there discussing blockchain and antitrust, where a court of justice might actually hamper the innovation in the space, for instance, by saying that all forks are anti-competitive. I don't want to be too technical over here, but it's very important, again, to understand what's the technology. And same is true when it comes to certain algorithmic pricing technologies, to try to address the issues, but do it in a way that preserves the technology chances of survival. And from the work of Darwin, what you learn is that survival is possible when you do have the elements that differentiate you from other species and varieties. So that's something which, in my view, is central when it comes to all the issues, the tech issues that we've been discussing. Try to address it, but sometimes there are different ways to address competitive issues, and one will actually preserve the technology at stake when the other will actually almost eliminate all elements of differentiation, which is not, in my view, the right way, which leads to something which is dear to me, and I will have some announcements to make in the coming days and weeks, but something that I will call law plus technology, which is how to combine the two instead of just creating a full confrontation between the two, which I argue is not benefiting the common good. So I hope I answer your question when it comes to those type of practices, but again, evidence, and try to come up with some new way of approaching it so that when we have the evidence, we can actually deal with those practices the right way.
Thank you, Professor. It seems that 20 years ago, most of the law students were trying to run away from math and technology into law. But today, the situation and the whole framework is changing, and I'm looking forward to it myself personally. So I think we're coming up to the end of the conversation. Nidhi, do you have any more questions for Professor?
No, I think I don't have any more questions for the professor, but would love to know from the audiences that if any one of you has a question for professor, we will be happy to take those questions. I think there's one question we have from Achman Shekhar, and he is from India. He's from National Law School, Hyderabad in India. And he has a question that for Professor Thibault, that sir talked about the problem with the conventional definitions in regulatory legislations. Can you please also talk about how these definitions can be revised to make them more suitable for effective policy implementation?
Sure. I mean, that's perfect timing. I'm promising you this is not a setup, but this is perfect timing because on Monday, we'll be publishing our next paper within the Computational Antitrust project, which is all open access. If you just Google or Bing Computational Antitrust, you will get to it. And that paper is about precisely how when doing the consultation for the DMA, the European Commission asked all the stakeholders, big companies, small companies, entrepreneurs, to explain what were their thoughts regarding the DMA. And what they've done is that using computational tools, you will see which ones, they actually came up with some fascinating results showing that most of the time when small companies are using the term gatekeeper or are using the term dominance, they do not mean the same thing as the big companies using the same terms, which of course creates issues when it comes to enforcing the law because different agents on the market won't understand the legislation the same way. And you could argue, and you will see in the conversation that I've recorded with the author of the paper, that you could conduct the same analysis regarding different agencies. Even within the European space, you could prove potentially, should it be the case, that the European Commission is not using the term gatekeeper the same way in the DMA than what the European Commission did in competition law cases and what the European Parliament is doing, et cetera, et cetera. So again, it seems that technology and here computational tools shows us the way toward convergence in the substance of competition law, which is fascinating and, to be frank, not something that I expected even 2 years ago when I thought that first substance was necessary to be more convergent before we could use the right tools. But it seems that it's a back and forth, which is fascinating, at least in my view.
Thank you, Professor. I would just ask one final question. I think we don't have any other questions from the audience at this moment. So I've seen in one of your articles on your blog that your take on the DMA, and one of the things that I would like for you to explain a bit further to us is I think you have had a take of that oligopoly should be fostered in the new DMA. So if you could elaborate on it a little bit further for our audience.
Sure. I mean, first of all, I should say that oligopoly is a concept created by a dear friend of mine, Nicolas Petit. He has a book on the subject, which you can buy right now. And the idea is that indeed you see competition between the tech giants. And so you see Google competing in the space for social media, you see Facebook competing in the space for research, et cetera, et cetera. And it seems to me that in a sense, the DMA is very conservative. Why is that? Because from at least the draft version that we have, the DMA is very much focusing on competition between the big tech companies and the startup. If you look at evidence, it seems that this is something that is not very common and that the pressure for indeed small startup to compete against Google is too high for them, for most of them, to be able to come up with something which will be valuable or at least lasting on a permanent basis. Something which is not in the DMA as it stands is competition between the tech giants. And so if you do say that indeed a tech giant, let me take Google as an example, cannot combine data coming from different services to improve new services. And if you do say that Google cannot self-preference anymore, it means that should Google come up tomorrow with a new social media, Google won't be in a position to use its market's position in the search market to promote the new social media, which in turn benefit Facebook, because it means that Facebook dominant position, or at least position in the social media markets, is not protected, because it is always possible for TikTok to come up, but at least Facebook knows that Google cannot use its existing market power to compete. And by the way, the exact opposite is also true. The exact opposite is also true when you talk about Amazon, when you talk about Netflix, and all of those big platforms and aggregators. So in a sense, the DMA is freezing the market by preventing that big tech companies are using certain practices against other big tech companies. And so what I was arguing in a short article is that it might be an idea to say that indeed, big tech companies cannot self-preference against startups. However, if they try to do that in a way to compete more efficiently against all the big tech companies, then it is pro-competitive, because we want Facebook to compete against Google and Amazon, et cetera, et cetera. So I'm not too sure that the progressive agenda actually is reaching the point to where we can improve competition and benefit consumers by freezing the markets, which again relates to the conversation that we had, complexity theory, and try to understand movement and interactions between agents. It seems to me that the worst type of anti-competitive practice are the practices freezing the market, because then you have no complexity anymore, the market becomes static, and that's where prices go up and innovation goes down. So that's, at least this will be one of my top priority as an enforcer. And I wish that the DMA can also foster more dynamic competition instead of trying to put a brake on it.
Thank you, Professor. It's sort of we would like to have an exception, I guess, to big tech competing against each other, as opposed to them competing against, let's say, smaller or medium-sized enterprises. So we have just another question, and I think that will be the end of this conversation. We're about to hit the hour mark. So Amazon is planning to open up physical stores. So one of our attendees is asking, how will it affect the competition law regulation and enforcement, as it is already in a sort of a dominant position in the online platform market? If you could have your take on it.
Sure. I mean, those are very complex questions. Of course, I've read somewhere on Twitter that someone was saying, well, it's very convenient to Amazon to open such physical stores because they got rid of competition in the space and now they can enter the markets. But should it indeed be the case that they got rid of competition because online shopping experience was much better, then I'm not too sure why the physical Amazon store will succeed. So it's a bit of the story of the egg and the chicken. But trying to answer the question, it will probably affect cases in the way by which Amazon might be able to leverage the online shopping experience to the market for physical stores. I'm not too sure how this will be possible, but I'm sure that there is probably a way. However, when it comes to the market definition online, I mean, this is an ongoing discussion. Should we take into consideration physical stores, brick and mortars, and also online shopping experience or not? There are lots of case law in the matter, and I'm not too sure that the Amazon case will change the case law in that regard. So wait and see. Full of surprises in the field of antitrust. It's very exciting because, I mean, on a daily basis, you have new cases and new legislation. So if you enjoy sleeping a lot, antitrust is probably not the right field for you, unless you enjoy the anxiety of not being able to read everything that's happening in the space. But when it comes to Amazon, this is probably not something that will change the entire landscape. At least I hope so.
Yeah, and that's where all the music listening comes into good foray. So thank you, Professor, for this amazing conversation. I think we had a blast here talking about competition law. I know it's all legal topics, but anyways, it was interesting for us. So of course, if you like to continue watching this kind of talks, please make sure to follow the Institute for Internet Antitrust Society on the social media channels of your preference. I once again have to thank Professor Schrepel for taking the time to talk with us today, and we sure hope so that you will be our guest in the future events. Thanks again. Thanks also to Nidhi, and we sure hope to see all of you in our next conversation.
Yeah, thank you so much, Professor Thibault. Personally, it was a truly enriching experience to hear you talk, having been a part of Stanford Law and to read so much of your work on computational antitrust at the Codex Center. It was personally enriching for me to have you first-hand answer to my queries and to my doubts on computational antitrust. This intrigues and motivates me to work all the more in this area of law. And thank you so much again to all the participants as well who joined us, and to Peter and to Professor Thibault as well. Thank you so much.
Well, take care and congratulations on everything you're doing within the Institute. I think this is wonderful. So
Thank
see you soon. Bye-bye.
Bye-bye.
Thank you. Thank you so much. Bye-bye.
Bye-bye.